have case 17249, which is arraignment for one count of a protection order violation. And we have 24 DV 1206 for a pretrial. You want to take the arraignment first, Mr. Stashevsky?
Yes, Your Honor. And I spoke with Mr. Bourdon about the arraignment for this case. I advised him of his constitutional rights. I do believe he understands those rights. We are seeking the appointment of public defense. I'm his attorney of record on some other matters. So we request the court appoint public defense. We are not contesting probable cause for the purposes of today's hearing only. And then we would request the court enter a not guilty plea.
All right, and I will do that. Mr. Bourdon, your plea of not guilty to the protection order charge is entered. I'll also appoint the public defender for you on this new case along with your other matter. And then Ms. Pritikin and the state have a recommendation on conditions.
PR, no criminal law violations, no firearms, deadly weapons, abide by the no contact order.
Any objection to any of that, Mr. Stashevsky?
No, Your Honor.
Okay. All right, so Mr. Bourdon, you're released on your own recognizance on this new charge. Don't violate the law, don't possess firearms or dangerous weapons, and comply with the no contact order. And that no contact order is on the malicious mischief charge. Okay, so now we're gonna set future dates for you. See what you already have coming up so we can kind of consolidate these things. So not 24 DV 923 is coming up for trial confirmation on February 19th. 1206 is coming up for March 12th. All right, let's set this for February 19th, just so he's got a next date.
And Your Honor, I don't, just so the court is not double working it, with the other misdemeanor cases, the 3 other misdemeanor cases, we prepared a waiver of speedy trial for those today.
Mm-hmm.
If that helps inform scheduling for this new one.
Yeah, what I'm trying to do here is just set his pretrial for his next court date that's already set so that he doesn't have another court date to add to his list. He's got Superior Court too, so he's got a lot going on. All right, that's February 19th at 10. And then I've got 24 DV 923. It says it's on for no contact order motion. I have to say I haven't reviewed that because I didn't realize that that was on. But it seems unlikely there's going to be any change to that order.
I believe the protected party is present on Zoom, Your Honor.
Okay. All right, it looks like that was filed on February 23rd. And that has not been heard yet, so. All right, then that's Mackenzie. I have a hard time reading that handwriting.
Mary Chris.
All right, and I know you want me to remove the no contact order, and you filed a written request that I do that. Is there anything else you want me to know?
This is my second request. I just wanted you to know that the first time that we had this incident, we worked really hard to have him detoxed at 4 different hospitals, me and him. And then when we got home, we couldn't get any connection with the pharmacy to get his medication. And soon after, that's the first incident. And then he became homeless after that no contact order. And I still left food on his car when he was on the side of the road. And then he was finally able to go to treatment. And I knew this because I had a ROI to his clinic. And then I know that it was in place, but I didn't want him to be homeless again. So I had him come back. But I was talking with the treatment place, and he was started on a medication, a new medication that was making his behavior off. But I wanted him home because I didn't want him homeless. And then that happened, and I didn't want him to leave. I thought he was going, but he wanted to go home. So it was my fault on the second incident because I was really angry with him. And in his defense, with me pushing him out, was that he defended himself against me. So it's I'm taking anger management to help with this, but I just want him home, and we're trying so hard. This is gonna affect our family for 6 years at least with everything that's happened. So I'm asking if we could remove the protection order so he's home with me, if that's okay.
Yeah, at this point, I don't think that's a good idea. And Mr. Bordone, this is your responsibility to comply with the no contact orders in this case and in your Superior Court case. You have a pattern here that has emerged of being, charged with the crime. The order is put in place. You've been accused of violating it now on 3 occasions. The order's not going to change at a minimum until there's a period of compliance with the order. So at this point, and Mr. Bordone, I'm directing this at you because I want to emphasize it's your responsibility to comply with the order. It doesn't matter if Ms. Domingo says it's okay if you come home or it's okay if you contact me and violate the order. She clearly wants you to contact her, but you can't, there is no way that she can give you permission to do that. You have to have the court's permission to do that. And part of the whole problem here with your situation is that there are accumulated and repeated allegations of violating the order. And until that stops, I'm not even going to consider changing it. Right, so your next court date is set. I told you it's February 19th. Ms. Domingo, you're more than welcome to attend those hearings. And I'd urge you to work with the prosecutor's office to express your concerns there too. But that's all we're going to do with Mr. Bordone's case this morning.
Can I file another request before then, or?
You can file requests, but keep in mind that the court isn't going to change the order based on the number of requests to change the order. The court's only going to change the order if it's appropriate. And that means Mr. Bordone has to do what he has to do to comply with the order and to change his situation. All right. So I don't want you to be under the impression that you can just ask as many times as you want, and then based on the number of requests, the court will change the order, because that isn't how this works.
Okay, Your Honor.
All right. So you're welcome to attend any of the hearings that you would like to.
So one thing my employer has always taught me is to show up with a smile. For some reason, my employer doesn't think I smile enough. And so whenever I go to sites, I'm always encouraged to, even if I'm not happy, put on a happy face. I wish somebody would have told this Zachary whenever he goes to court to put on a happy face. He certainly doesn't have one. But no, this isn't the only time that she's done this. This is the second time on this case, but he's been in and out on different cases, and the judge is able to see all that, and the judge has had enough of it. So if she hasn't had enough, I don't really know what to say. The judge is making better decisions than she is for her. So hopefully she'll get through this, and hopefully she'll be okay. But we've got a bunch of court. Thank you everybody for coming out. thank you so much for all the moderators and keeping everything nice and happy out there. Everybody be good in these chats. People see that, and it's embarrassing when you act silly. So everybody be good there. Let's look over at Judge Simpson.
Court does call the case of the people versus Jenny Lou.
Ashley Long, people.
Good morning, Assistant Public Defender Lauren Perny on behalf of Miss Lou. Miss Lou, please state your name.
Jenny Lynn Lou.
Thank you.
So, Your Honor, I'm sure you've heard this recently, but the prison has changed their visitation policies. We've been, yeah, well, we've been waiting for over a month to try to get approved to even go see Miss Lou, even though we've met her before. So actually have not been able to see her, I think since December. So I asked for adjournment of this. Our social worker's been trying to get it out there. It's just issues with bureaucracy. So
it's not the attorneys getting in, it's
anyone. So it used to be we just emailed our bar cards, they'd schedule the appointment. Now you have to fill out a form, you have to mail it to the prison. They have to approve you in some way. I don't know.
all right.
So it's been difficult. And I want to apologize to Miss Lou. We've been really trying, Miss Lou, but we've just been having difficulties.
I understand. Is it like a way around it where I could just, I mean, go through without having to be adjourned? Like I have to see the social worker again or something?
I wish, but we gotta talk about things. So
All right.
I also know that there's more than one case that Miss Lou has right now, so that's also part of what's happening, is she has I believe, a felony as well.
For me?
yes.
Okay. All right, let's, when is that case scheduled?
Maybe tomorrow, I think.
I think it may be tomorrow. Yes, it is tomorrow.
It's tomorrow.
Yeah.
Are you handling that case or?
Not tomorrow, no.
Okay,
But he knows,
and he's having the same issue.
correct, yes. Yes.
All right, so timing wise, how much time do you think you're gonna need? Because you're right, this isn't the first I've heard of it.
I know, it's been an issue. I mailed in the application about 5 weeks now. I followed up
5 weeks ago?
5 weeks ago. I followed up with the prison and I haven't heard back of even the status of my application. So it's been a issue.
5 weeks.
Yes. And they don't accept it by email, which I don't understand, but
You have to mail it?
you have to mail it. I know.
Yeah.
Not gonna say what I'm thinking.
So I guess, I know Miss Lou is
If there's any way-
obviously in
if there's any
custody.
way the court can help, let us know, because
I appreciate that, Your Honor.
Ellen and we've delivered mail before, so we'll do what we can. All right. How much time?
His
Why don't
part-time
I-
job is a
What?
part-time job as a post officer. I like that. I guess to go out 3 or 4 weeks if that's possible.
Yeah, why don't we?
So Miss
do
Lou
that,
doesn't have
because-
to come back.
And it's likely, Miss Lou, tomorrow your case is also going to be adjourned for the same reason, but we'll try to keep them close together like we have. Okay.
Yeah, I appreciate that.
March 5th.
Thank you, Your Honor.
All right, I'll adjourn this matter to March 5th, 2025, 9 a.m. And again, if there's any way the court can help out,
Appreciate it.
whatever I can.
Thank you. Thank you, Miss Lou. I'm glad I got to kind of
Thank you.
explain what's going on.
Yeah, I actually just saw the prison counselor and she accepted the forms too. I got your visiting applications and stuff too, so.
Okay, so that's good. Thanks for the update.
All right.
Yeah,
She gave
thank
you an
you.
update, but nobody else did? That's amazing. Thank you, Miss Lou.
Appreciate it.
Court does call the case, people versus Gentian Frame. And they messed
Ashley
up.
Long, people. There's no counsel.
There's no counsel.
I like. It's
Oh. You called Miss Perny no counsel?
No.
Wow, 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 wow. Just, no, you said there's no counsel.
I'm counsel.
I know, I feel that way. Apparently, Ann doesn't. All right.
No problem. Good morning. Assistant Public Defender Lauren Perny on behalf of Ms. Frame. Ms. Frame, please state your name.
Yes, good morning, Your Honor. This is Janiston Frame.
Janison Frame, I knew it. And I
Every
just-
time you mess it up, every time we're gonna
Whoa,
hold you
whoa,
accountable.
whoa, you didn't, but I acknowledged that you didn't have to come at me like that, but okay.
It's a new year. We're gonna start off fresh.
Okay.
Your Honor, we have been here a few times.
Oh,
We are asking for another adjournment. However, we
another German where I gotta try to call her name? Oh, wow. Okay, go ahead.
You'll get it next time.
Ms. Londi and I did speak about a potential resolution. I just have not been able to relay that to Ms. Frame. So I would like some more time to have another conversation with her about resolving this case.
All right.
That's correct. We talked yesterday, the offer would be, no contest is charged for the prosecutor to defer its sentence, but of course, Ms. Kearney needs time to discuss what that means for her client.
All right. I can do February 19th, I think it is.
Just don't do
Or-
February 26th. It's my birthday.
I'm gonna set it right on that date then. No.
I
I'm
think
just gonna hold a special docket just for her.
no. I think the 19th should be enough time, Your
The
Honor.
19th will be enough. All right.
Thank you.
I'll adjourn the matter February 19th, 2025 at 9 a.m. Bond will continue. Ms. Frame, thank you. Have a great day.
Thank you, you as well.
February 19th, 2025, 9 a.m. on all these matters.
Thank you. And apologies for not
No, it's
realizing
okay.
where all of his bonds are, but glad we got it taken care of.
No, according to Ann, she expected it because you're nobody.
Sorry?
You did your
It was what Ann was saying. It all started this morning. Tonight. I'm having that conversation. Whoever calls
That's correct, Your Honor. I just have not had a chance to
Okay.
go over it in detail with Ms. Hike. I must mess it up. So I'd ask for the briefest of adjournments if possible. I would ask, Your Honor, if this is possible. She babysits on Wednesdays. Do you think we could set it for a Monday docket? She's a really good grandmother. I know it's a little unorthodox of a request, but
If not, that's fine, Your Honor. I just,
it's not coming from her, honestly, it's coming from me.
That's not true.
Well, she said she babysits and I want to make sure that she can spend time with her little granddaughters who sound so cute.
See, Kearney's doing this on purpose because if I say no, they're gonna be like, oh, he's so mean. He's just gonna make her miss time with the grandkids. How many grandchildren do you have?
two granddaughters, Your Honor, 4 and 1.5.
Wow.
And they live downriver, Wyandotte.
Oh, okay. So you have to travel to get
I
that.
go 2 days a week, actually, Wednesdays and Fridays, so. It's fine. It's, if not,
It's really not, she did not ask. I am making this ask. Well, I guess on behalf of her. but-
Alman, you believe what Kearney's saying?
Of course, Your Honor, she's an officer of the court.
Wow.
My defense attorney
Wow.
back
All
there.
right, I'm not talking to you either anymore. Marston, okay. Any objection from the people in setting it that special time? Of course not. See? So now I have to do it. I was hoping that Lundy would come through. Yeah, we object.
Next time.
But that would be at
Don't forget 1 p.m.
1 p.m.
awesome. Thank you.
Okay. Listen, Your Honor, the cost of daycare out here, we need to.
I,
need
you
our
know what?
grandmas.
Why? You're just piling on. You're just piling on here.
I know, I need to
Kearney,
zip it.
Kearney, I'm gonna do this for her.
Thank you, Your Honor.
I will set it March, well, I'm gonna do it for the little ones. I'm not doing
Thank
it
you,
for the
sir.
big people. Or March 3rd, 2025, 1 p.m.
Thank you.
Don't even start. All right.
Have a good day, Your Honor.
You
Thought it was good to show Judge Simpson being in a good mood today, because sometimes these judges are not in a happy mood. They see too much, see it too often. So it was good to see Judge Simpson there. Let's go to Judge McNally. He had a good one. Fella wasn't doing well at Five Guys.
We're even out there yet?
They just came in, right?
Good morning, Detective.
Morning, Your Honor. How you doing today?
Not too bad. How about yourself?
Doing good. Doing good. It's Monday, so.
Are we ready on Mr. Sorrell? Gregory Lynn Sorrell.
Yeah, my partner's
25W
grabbing him up the
70
cell right now.
Okay. 25W702221. I have two files here. Lisa, do you know why?
Police Department, Your Honor.
Raise your right hand. Solemnly swear affirm at the penalties of perjury. The testimony given in these proceedings will be the whole truth, so help you God.
I do, Your Honor.
Go ahead.
It's on January 31st, 2025 at approximately 9:27 p.m. Officers were dispatched to Five Guys in Woodhaven at 23414 Allen Road. On reports of a male in the business wearing all camo being disorderly and threatening to assault employees. Upon arrival, officers observed Gregory Sorrell sitting in the lobby with miscellaneous items spread across the table and the floor. Officer Pozlico observed Gregory to be barefoot inside the establishment and rubbing lotion ointment on his barefoot with lotion, being on a table and chair and floor.
I got it.
Okay.
Come on.
Officer Pozlico then approached the employees and began to ask them what happened. Sorrell began yelling at them that they were lying, preventing Officer Pozlico from questioning the caller. Should be noted, there were several customers inside the business at the time while Sorrell was yelling over Officer Pozlico, and he observed Officer Pozlico through customers turning their heads and staring at Sorrell as his behavior was abnormal. Officer Pozlico then had to have Gregory Sorrell stop yelling so the employees could advise what happened. Per Caden Booth, an employee at Five Guys, Gregory entered the business and purchased food. After purchasing food, Gregory entered the bathroom and smoked a cigarette and stayed in the bathroom for approximately 30 minutes. Caden stated Gregory then exited the bathroom and then sat at a table for approximately an hour before he entered the bathroom once again and he began smoking. Per Caden, when Gregory was done smoking a second cigarette, he began to move items from his two shopping carts inside and began spraying them across the table he was currently seated at. Caden,
Say that again. That last, wait a minute. Whoa. Say that last statement.
Caden stated that Gregory, when he was done smoking a second cigarette, he began to move items from inside his two shopping carts and began spreading them across the table he was currently seated at.
At Five Guys.
Caden stated, yes. And Caden also stated that two customers then entered the business and advised him that there were two shopping carts blocking a parking space directly in front of the business and that it was inconvenient. Should be noted that upon Officer Pozlico's arrival, he observed two females exiting the business. However, the information was unable to be gathered as they left while he was interviewing the employees, which he believes these two females were the customers that complained to Caden. Per Caden, his manager advised his fellow employee Jason Hasselbeck to go and move the shopping carts as customers were being inconvenienced. Jason stated he then went and began moving the shopping carts from the parking space approximately 5 yards to the west from the parking space onto the grass. Per Jason, Gregory then got up and ran outside towards him, yelling, "Hey, and quoted, "Motherfucker, I'll whoop your ass." Stated this didn't make him feel threatened as Gregory is much larger than him. Should be noted, Caden stated he observed this happen and he felt he needed to step outside to assist Jason as he was worried because of Gregory's size. Per Caden, there were several customers who witnessed Gregory causing a commotion directly outside the front of the business while running towards Jason and swearing. Caden stated that there were approximately 3 customers inside the business when this happened, and he felt that their peace was disturbed as all the customers began to turn their bodies and heads and stare towards Gregory. Per Caden, the regular flow of the business was disrupted due to Gregory's actions, and the business customers should not have to see or hear that. Referring to Gregory running towards Caden and yelling while swearing. Officer Pazlico waited for backup from Officer Alderman to arrive due to Gregory being combative in the past. And once on scene, they placed Sorrell in handcuffs and arrested him for his early conduct. He was securing the backup patrol vehicle and he was trespassed from the business, transported to the station where he was booked and processed. Station.
Any evidence he was under the influence of alcohol? Listen, any evidence he was under the influence of alcohol or drugs or both?
No evidence of that, Your Honor.
Good enough. Based on your testimony, I find the crime of disturbed the peace was committed. There's probable cause to believe that that crime and the crime of disorderly person was committed by the defendant, Gregory Lynn Sorrell. You can bring him in for arraignment.
Thank you, Your Honor.
Mr. Sorrell has been in front of me multiple times on the same kind of charge. Good morning, Mr. Sorrell. How are you?
I gotta go to the hospital. Man.
Mr. Sorrell, your name?
What, sir?
Your name, please?
L. Sorrell. Gregory L. Sorrell.
Does he stand me away from a reading?
Good morning, Judge. Mazen Gift, on behalf of Mr. Sorrell, for record purposes, we'll stand mute.
Not guilty, please entered. You can go ahead and argue bond.
Judge, I mean, we're asking for a personal bond at this time. I understand that Mr. Sorrell, excuse me. I understand that Mr. Sorrell does have multiple charges and prior issues regarding the same things that he's facing today, Judge. However, he is homeless. He's been homeless for the last 5 years. He's currently unemployed. Therefore, it would be very difficult for him to post any type of monetary bond, Judge. He is also 64 years old, Judge, and does have an issue walking due to some issues, frostbite with his toes.
Frostbite, I have to go to the hospital right now, Judge. The hospital right now I need to go to.
What are you hang on. What are you asking for, Detective?
Your Honor, I was gonna ask for a cash bond, just due to the fact that if he walks out here right now, we're gonna be dealing with this again. That same day that this happened, we had 3 prior documented cases of other businesses calling regarding him disturbing their business and flow of traffic.
I have $6 in my account. If you want that, that's all I got.
Mr. Sorrell.
Yeah.
I've tried to maintain my patience with you over the years, but it's the same thing over and over and over.
Sir, I have frostbite. I have to go to the hospital right now. I'm frostbit.
7,510%. You cannot leave the state. You cannot violate a law. You must appear in court as directed. No contact with employees of the Five Guys store in Woodhaven. No contact with prosecution witnesses. You're not there at 23414 Allen Road in Woodhaven or any other Five Guys.
Yes,
and you're not possessing any firearms. You're not possessing firearms or other dangerous weapons. We're going to give you an early court date. I'm going to give you February 4th for the record. He also has warrants out for his arrest. I don't know what else to tell you, Mr.
I want all those set up, for courts, because I'm going to court over all those. They were like walking the sidewalk that was icy, going on the street, and okay. Going to all those.
7,510%. Thank you.
Thank you.
Laney. Alastair Xavier Laney 252-644 598.
Checked out by the UMass yet? No.
I thought it was funny. He treated that court like it was Tuesday. It was just another day for him. He goes in and out all the time, so I don't know why he wouldn't want to stay there until at least summertime. If I was in his situation, I'd at least want to stay there till spring. So I don't know, but he wanted to get out. He had to go to the hospital. So I think Kimby's got it right there. All right, y'all want to go to Judge? Let's go to Judge Boyd. Let's see. Let's go there.
All right, there's only one motion to revoke. Is that correct?
That is correct.
All right, court is calling 2020 CR 0572 State versus Israel Medellin Jr. Could I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense?
Boyd Barrera, Jr.
And are you Mr. Israel Medellin?
Yes, ma'am.
All right. Are you the same Israel Medellin who was placed on deferred adjudication in 2020 CR 0572 for the offense of evading arrest, detention, using a vehicle on February 10th, 2022 for a period of 3 years? Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor. Violated condition number 1 on or about the 20th day of July, 2023, in Bear County, Texas. The defendant, Israel Medellin Jr., committed the offense of unlawful carrying of a weapon in violation of condition number 1.
How do you plead to that? True or not true?
True. Your Honor, will waive the remaining violated condition.
All right, any objections to the waivers?
No, Your Honor.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in the prison and up to $10,000 fine? Is there a proposed agreement?
There's not an agreement, but there's a proposal, Your Honor.
Yes.
There is partial agreement. The agreement is that he pled true to the UCW. The state will be taking into consideration that cause number, which is 713157 at a county court number 8. And also at the same time of that incident, we're taking another case into consideration, which is the unauthorized use of a motor vehicle, which is 2023 CR 9587. And we'll send those dismissals to the court. Thank you, Judge. And Judge, the state's recommendation is revocations that are not agreed upon.
All right. So the state is recommending revocation. Do you have any witnesses?
Yes, Your Honor, I do. My client.
All right. You want to raise your right hand? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right. You can lower your hand, state your name for the record.
Israel Medellin Jr.
All right. Defense, you may proceed.
Yes, Mr. Medellin, tell the court what you do for a living.
Yes, miss, I make music for a living.
I'm sorry, what?
I make music for a living.
Music,
I've been doing it for 5 years. It's been helping me pay my house, take care of my family, my son, my wife. It's what I do for a living. It's how I get monthly income. It's how I pay all my bills. It's how I survive.
And explain to the court who your family consists of.
Me, my wife, my son. He's the third, and then I'm having a baby on the way too.
All right. So let me just tell you right now, the crux of the court's questioning is going to be, what has he completed since he's been on probation?
I didn't hear you.
Oh, what has he completed since he's been on probation? Because the only thing I have before me now is the fact that he picked up an unlawfully carrying of a weapon. So what has he completed on probation?
Miss, I've reported every month. I was
No. I'm just trying to get to what have you done on probation? Sometimes, just a second, take a deep breath. Sometimes this is what the issue is. You will have somebody come before you and maybe they have a motion to revoke and they picked up a new case. So what do I know about you? What I know about you right now is that you were placed on probation and you committed a new offense. So I'm trying to figure out, what have you been doing since you've been on probation? Everybody always comes in, and I say everybody, and 99% of the people come in, I have a baby on the way. And you know, my mindset is always, why were you not thinking about that before you picked up a new case? Or people will tell me, my mother is in the hospital, or my family member is in the hospital. And you know, my question always is, why were you not thinking about that before you picked up a new case? So I'm trying to figure out, what have you completed on probation? Were you reporting? Because your conditions of probation are to report. Were you reporting?
Where?
Were you reporting? Did you report on a regular basis?
Yes, miss.
So you've never missed reporting?
No, I may have missed a date or something, but I always try to make sure I stay on top of it. I may have missed a date. Yes, I have.
Here's the thing. We're not talking about maybes. My understanding, the probation officer's here. So were you reporting regularly?
Yes, miss. Yes, I was.
Did you ever miss reporting?
No.
All right. Have you completed any community service hours?
I was supposed to pay them off. Yes, I was trying to pay them off. I was trying to get your permission actually to pay them
Now,
off.
so here's the thing. You need to listen to my questions. You've been on probation since 2022.
Yes, ma'am.
Did you complete community service hours?
No, miss.
All right. Next question. Did you complete parenting classes?
I completed one of them. Yes, miss, I did.
No. Did you successfully complete your parenting classes?
Yes.
So what I mean by that is all the classes, if parenting classes were 10 classes, right?
Yes, I took them all. Miss.
Did you get the certificate?
Yes, miss, I did.
All right. The next question. Did you participate in field visits?
What is that, miss?
Oh, probation comes out to your house to check on you to see that you're doing well.
Yes, miss, I know, they have my address. I never, I don't know how that goes. They never contacted me to go to my house, but they have my address where I live at.
All right. So counsel,
Yes,
any other questions?
yes. Are you on medication?
Yes, miss. Also, there, I do have a medicinal marijuana license, and I know I came out positive for marijuana, but I get prescribed THC oils, and that helps me with my insomnia, my PTSD, and it helps me stay asleep at night. That's the only reason I have positives on there.
He should have been on in my opinion, Judge, a mental health doctor. He has serious PTSD and anxiety, and
Well,
he needs cognitive thinking. It was recommended on this particular case, Judge. And I couldn't agree more. Getting him
Well,
to,
did he take the MRT? Because that was one of his conditions.
What does that mean? I'm sorry.
Oh, to help you make
better decisions.
better decisions, to help you realize the correct moral choice. For example, not to pick up an unlawfully carrying of a weapon because you're on probation.
No, miss. I don't think I took it. I don't think so. I don't recall.
Okay.
It's been a while, miss. Atascosa County did sit me down for 7 months, so that is a reason why I may have not been reporting, or I didn't have no reports from August 4th to February 12th. I was incarcerated in Atascosa County last year. But everything before that, miss, I had been reporting every month. I had been taking my UAs every month, miss. I had been complying and trying to get this out the way, miss. Like I said, I have a family I take care of and rely on me so much. And I just found out I have another baby on the way. It's not nothing I wasn't thinking about. I just found out, miss. And it's just, it's news that's.
Well, everybody knows how babies come to be.
No, yes, miss. I understand that. I'm just saying, like, I wasn't aware of it. I'm not trying to continue to live my life like this. I do have a family that depends on me a lot, and I'm just trying to get out there and show them I can do right. My son depends on me a lot, and I'm
very talented singer, musician, makes music, writes music. He's very creative, Judge, but he's got some mental issues.
Mm-hmm.
And I do make music, and I have a very big following, and I feel like that is the reason I get harassed, honestly. And I've tried to.
Who's harassing you? Was probation harassing? Because all they wanted you to do was report on a regular basis.
No, miss, it's not probation.
All they wanted you to do was the MRT. And here's the thing. You have been on probation since 2022.
Yes.
And everybody knows if people successfully complete their probation, normally, I would say about 90% of the time, if they complete everything and they ask for early termination, I usually give it to them.
No, I understand, miss. It started off rough for me. I can't lie. It started off rough for me because I wasn't used to probation. I wasn't used to people telling me what to do and how to do it. So it was new to me, miss, but it's something that I know I can get done.
How far did you finish school?
I went all the way to 11th, 12th grade.
All the way to the 11th?
Yes, all the way to 11th grade. I went to 11th grade, miss. And that's honestly something I'm working on right now too. Is I have my GED in the works. I need to finish. I think I need to get 3.5 more credits and I'm done with my GED too.
Mm-hmm. All right. Any questions? Any more questions?
No, ma'am.
State, any questions?
There we are.
All right. Is the probation officer here?
Yes, Your Honor.
All right. If you'll come forward, please. Hi. Thank you so much for waiting patiently. Could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
Moses Lozano.
All right. And so I know that you have been here since this morning. So I wanted to make sure that if either party wanted to call you as a witness, that they would have a chance to call you as a witness. All right, and I know you were being brought because this was supposed to be a contested hearing, but you know, he's decided to enter a plea of truth. So does anyone have any questions for the witness?
I do, Judge. May it please the court, sir. Thank you for staying. Saw you here at 9 o'clock this morning and you've been here all day. I saw a notation that I think you wrote as far as a recommendation to the court. Would you explain on the record what's available that you think that he could use and needs regarding cognitive reasoning and thinking?
Well, we recommended ISF for cognitive.
And why did you recommend it?
That's what you usually do with probationers that tend to need more guidance mentally and in general.
Okay, and
Including the
for the record,
responsibilities.
what is ISF?
ISF is a program run by the state that probationers go to. They stay there for 90 to 120 days and receive the treatment they need, whether it's mental health, drug abuse, or they'll touch on it.
Sure.
But for him, it'll be cognitive, so it's more mental than drug abuse.
But can he also get drug abuse assistance there?
No,
Or is it just
the
mental?
primary would be
Mental. And you believe that is something that he would benefit from?
yes,
And you did recommend that, correct?
yes. Thank you.
That's all I have, Judge.
Any questions?
Yes, Judge. I see that your recommendation, sir, was this ISF program. And you obviously are the one that filed the motion to revoke, is that correct?
Yes.
And what would cause you to actually recommend revocation for an individual?
A probationer who consistently report and get arrested numerous times. However, it's always up to my manager to motion to revoke.
So really, it's up to the manager of y'all's facility, of you, to what that recommendation is that correct?
Yes.
Okay, because in this particular motion to revoke, there's two number ones. That means that he was arrested on two different occasions, or at least one occasion, the unauthorized use of vehicle and also the unlawful carrying of a weapon. Is that correct?
Yes.
And then there's also an allegation on here that he did not plead true to, which was the evading arrest in Hondo County or Medina County. Is that correct?
Yes.
Okay, so that's at least two run-ins with the law where he was possibly arrested on new charges, or at least alleged new charges. Is that correct?
Yes.
And just by you testifying now is that if he's arrested for additional charges, that may be a reason that you would recommend revocation of an individual. Is that correct?
Yes.
No further questions, Your Honor.
All right.
Thank you, sir.
So I just have one question. So was he reporting on a regular basis or no?
Your Honor, he failed to report in July 2024. After I found out he was released from jail on 06/28/24. I attempted to call him to report, made no contact.
Okay. All right. Does anyone have any follow-up questions related to that?
So his failure to report was because he was in custody? Or do you know?
I do know between the months of February 24 and June, he was incarcerated.
And obviously,
He couldn't report.
he could not report when he was incarcerated, correct?
Correct.
Thank you. That's all, Judge.
Just one question. He was not in custody in July 2024?
No.
Okay, thank you.
All right. Thank you.
Thank you.
Thank you.
Thanks.
All right. Anything else?
That's all, Judge.
All right. This is what the court is going to do. As previously stated, the court is finding violation of condition number 1 true. The court will take in consideration 713-157, 2023 CR 9587. The court is going to find you guilty and the court is going to grant the motion. Does anyone wish to speak to time?
Judge, he has served time for the offense that he has pled true to. And I respectfully submit that time will not help him mentally or emotionally or financially. And he is young. He's still somewhat immature. And he has responsibilities. He's acknowledged. And he's, as I say, Judge, very talented, very creative, and he works very hard at what he does.
Yes, ma'am.
But he makes no excuses for not being able to walk and talk and chew gum consistently. And that's his downfall, Judge. It's inconsistency.
All right. So, state what amount of time are you requesting?
Please requesting 5 years, Your Honor.
All right, defense, what are you requesting?
Judge, we're requesting that he be admitted to probation.
All right, so I'm not going to admit him to probation. So the state is asking for 5 years. What would you request?
Judge, we would request the minimum, of course.
All right. The court will sentence you to 4 years in the prison, give you credit for any time served. And the court will request the therapeutic community. The therapeutic community does not increase the time that you're in custody, but it will help you with any mental health issues or other issues you may have.
Will you retain jurisdiction, Judge?
Yes.
Thank you.
All right. Did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
Yeah.
All right, but you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, good luck to you.
All right, I guess I'm supposed to say something before we go to Judge Fleischer. Here's when I say something.
Ms. Fairman, you are charged with the offense of interference with the duties of a public servant. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. Officers were dispatched to a family disturbance, and the caller, the defendant's mother, stated that her daughter was walking around with a hammer and identified her daughter by name and as wearing a Barbie sweatshirt. In transit to the scene, the officers observed the defendant's prior mugshot and arrived and observed the defendant recognized by description and that mugshot. The defendant walked towards the officer, and the officers told her to stop, but she ignored them. She had her arms tucked into her sweatshirt, so they were not visible to the officers. The defendant attempted to walk past the officer, and the officer grabbed her arm, and she then laid on the ground and tucked her hands under her abdomen, and the officer struggled to get her arms out from under her. The defendant stated the defendant had a hammer in her left hand and would not let go. The officers then took her into custody.
What's she doing wrong? Was she walking while black? I mean, really, you tell me all she has is a hammer? She's walking around with a hammer. So I hammer stuff all the time.
Right, just what we have is there was a family disturbance. There was a description of her with the hammer, and she walked towards the officer, and the officer just told her to stop.
I mean,
so
there's
they could-
nothing. She's not doing anything. No one says that she's doing anything menacing with the hammer. She's walking with a hammer. I hang stuff on my house all the time.
Furthermore, Your Honor, there is more in the DIMS that in the complete DIMS, it says the complainant's defendant's mother identified her and said that the defendant's brother had taken a blue speaker, which upset the defendant. So the defendant went outside and kicked some trash cans over and pacing around a neighbor's vehicle holding a hammer. The complainant advised she was afraid of the defendant. So, yes, Judge.
Ma'am, I'm with you. Don't worry about it. I'm going to find no probable cause. Just hang tight with me for a second, okay?
Good, Judge.
Please. Just, yeah, take a seat for me. Hang tight, please.
All right. All right, Judge, counsel's approaching on page 29.
Is it Taisha Jackson? Taisha, Miss Jackson, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, Judge. The complainant and the defendant are in a dating relationship. On January 28th, 2025, the officer was dispatched to a disturbance in Harris County, Texas. Upon arrival, the officer met with the complainant, who stated that she and the defendant were in a dating relationship and that she told the defendant she was drinking too much. The defendant and the complainant then got into an argument when the defendant punched the complainant twice and bit the complainant on the chin, causing pain.
Okay. Ma'am, I'm going to find that there's probable cause to go forward with your case. Do we know whether the complaining witness wants to have contact with her or not?
Looks like we attempted this morning, but we're able to get a hold of the complainant.
Okay. I want to do what the complaining witness wants. So until I know that she wants to have contact with you, I'm ordering you not to have contact with this person. Do you understand? Shh. I'm also ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I'm going to put you in jail. No more PR bonds. You understand? A protective order has been issued in this case. I would get to know it. If you violate the protective order, the state can and probably will file a violation of protective order. It's one of the worst cases you can pick up. You understand? You know, in life, there are people that when they consume alcohol, they become very happy people. They're the life of the party. Everybody likes to hang out with them. They crack jokes. And then there are people when they consume alcohol, they turn into the devil incarnate. Get a clue. When you drink, this becomes you. For now, though, no consuming alcohol or illegal drugs. You understand? Tell me, do you have an income? Do you have an income? Do you work? What do you do with yourself?
I do hair. I do hair.
Okay.
Work from hair from home.
Do you have the ability to hire a lawyer, or would you like a court-appointed lawyer?
I can have a little club.
Sorry?
Appointed.
You want one? Okay. I'm going to have you sign a receipt with Victoria. I'll have you meet with Felicia for bond conditions, and then I'll have you take your signature box while I find your lawyer. Okay, ma'am? Please.
Right this way. All right, Fitch, next is page 31. Matthews, come on up. I can sign it, please. I'm sorry.
Hey, so Felicia, no weapons, no contact, no alcohol, no dope. What was the last name?
Matthews.
Matthews, okay.
Page 31.
You are Rebecca Matthews. Ms. Matthews, you're charged with failure to stop and give information, which is leaving the scene of an accident without exchanging information. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, man.
Yes, Judge. On November 5th, 2024, officers arrived to the scene of an accident and met with the complainant who had been in a wreck with the defendant. The complainant stated the defendant had made an unsafe lane change and struck her vehicle, damaging both vehicles. The defendant then exited her vehicle and began swearing at the complainant before stating she will take care of her own damages and leaving the scene, refusing to give the complainant any information. The complainant took pictures of the defendant's vehicle and license plate. At a later date, the officers were able to identify the person associated with the license plate, and the complainant was able to positively ID the defendant based on the photo the officer showed her associated with the license plate number.
So she took off.
She took off, and then they found based on license plate.
And I'm going to find that there's probable cause to go forward with your case. Have you run her license, Alex? Do you mind?
I ran it. Let me just pull it up.
Ma'am, I'm ordering you as a condition of your bond not to drive unless you have a valid Texas driver license and liability insurance in your name. Do you understand?
It's eligible, Your Honor.
If you're caught driving a vehicle that doesn't have insurance, or you don't have insurance in your name, I'm going to revoke your bond. I'm going to put you in jail. Do you understand? Yes or no?
Yes.
Do you have the ability to hire a lawyer, or would you like a court-appointed lawyer, ma'am?
Okay, a court-appointed one.
Okay. Can you file those conditions, Alex, please?
Which conditions, Your Honor?
Just no driving without a valid license and liability insurance,
Yes,
please. Okay, I need you to fill out an application for me. So what I'm gonna do is Deputy Grant is gonna give you an application. I'm gonna have you go to Victoria, sign a reset. After that, I'll have you take a seat in the jury box. Do not leave until you sign our bond conditions, all right? Do not leave until you sign our bond conditions. We'll have you come up here momentarily, please.
Go ahead and sign the reset. All right, Judge, next is page 4. Badon.
Going backwards.
For the resetting. It's a one resetting.
You're Stefan Badon. Mr. Badon, you're charged with tampering with a government record. You're facing up to a year in jail and or a $4,000 fine. This case is 755 days. Can you run his license, please?
Yes, Judge. It's not eligible, Your Honor.
You are not allowed to drive. That is a condition of your bond that I'm making now. You will be signing an affidavit with me today promising me, Mr. Badon, that you're not going to drive. I don't give a rat's behind what your excuse is. If you drive, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. It's an offense in and of itself. Do you understand? Unless you have a valid Texas driver license and liability insurance in your name. One more thing. If you ever take off on me again, I'm going to make your bond so high, your head is going to be spinning. I'm going to appoint your lawyer today because we need to figure out where this case is going. It is extremely old. So I'm going to have you come up here, swear to us that you're not going to drive. I'm going to get you to Victoria. We're going to have you sign a reset, and then I'll have you take a seat in the jury box, sir.
Judge, that was our last arraignment.
Okay.
No,
Hey, Hugh, you ready? Come on up. Hey, good morning.
Kevin Albert on docket.
Albert.
Page 21.
Sorry. Judge, it's in the case of 21.
Halbert. Okay, come up, Kevin Halbert.
Just get a quick reset so I can go over the evidence with him now that he's out of custody. And then we're still waiting on photos.
You're waiting on what?
Photos from CW. Photos of
Okay.
CW.
Have a seat in the chair.
Mr. Halbert, your case is 1,122 days old. You will get a GPS monitor today, so I know where you are at all times. And if you take off on me again, it's really not going to go well for you. Do you understand? I'm ordering you as a condition of your bond, you were charged with assault. As a condition of your bond, you're ordered not to have any contact with the complaining witness in this case and not to be in possession of weapons. Do you understand? So how long is it going to take you to get all the evidence? Because I'm ready to set this thing for trial, Alex.
So I'm looking, it looks like we requested the photographs on the 18th of January of 2022. So we'll just an escalation request and we can get in touch with the officers and the complainant and see when we get those photos.
Hey, I'm not doing long resets. I'm doing short resets.
Yes, Judge.
You get on it, get your photos.
Yes, Judge.
Can you also put an offer in there? Is there an offer now?
Yes, there is, Judge.
Yes, Judge. There is
Okay.
a time serve offer and
No, there's not a time.
no, there's a 180-day offer. I apologize.
Okay. The offer is 180 days in jail. I'm giving you 2 weeks to decide what you guys want to do. Get the photographs as soon as possible, please. Send it to an investigator today if you need to, Alex.
Yes, Judge.
Okay. In 2 weeks. At that time, when you come back, you need to be prepared to accept either the offer from the state or I'm going to set your case for trial. Do you understand? Okay. See you then.
Thanks, Judge.
Your Honor, may I approach when you have an opportunity?
Yes, Elena, I'm sorry. I totally forgot you were there.
No problem. I am approaching on Villatoro. First name is Andy. I can give you a case number because it's hyphenated.
Yeah, I don't see. Okay, what is it?
I'm in another county. I'm in.
That's okay. Don't worry about it, Elena. That's why we have Zoom.
Hold on. It is 253.
Okay.
2485.
It's Cruz Villatoro?
Yes.
Looks like we're just missing station video.
Where? What do you do with yourself these days?
Right now, I'm working with my brand business to talk and videography.
So you are working?
Yes, I'm currently.
Okay.
I just got here.
Your lawyer seems to be really upset with you. She wants to get off the case.
Sure.
It's time for you to work with your lawyer to work out a resolution. You know, do you work for free?
No.
Do you think she does?
No.
It's time to work things out. I mean, this case is 150 days old. You got to come a lot earlier. I get it that they go MIA, but you have also duty, have them come in, you know, periodically so that you guys can get on the same page and I'm setting your case off for a week. You guys need to get together to make things work out. Do you understand? Okay. So there's an offer that has been made in this case. I'm going to let them relay it to you at the right time. It's a really good offer, but you guys need to be on the same page. Do you understand?
Yes, sir.
Okay, take a seat for me, sir. So let's set it off a week. I'm going to have this print. He's going to have to come back. Let's see if things have worked out for you.
At that point, we could just do a regular reset.
No. But let's see if things can work out for you. If not, then we'll talk again.
Okay. I mean,
Okay? No. But Ms. Turner, don't worry about it. But let's see if things work out, and then come back in a week and we'll see. Let me know if you guys are happy or not. Want to take a test and you fail to go. If it ever happens again, I'm going to revoke your bond and put you in jail. Do you understand me? As it stands, I'm sending you for a drug and alcohol test now. So we will give you a normal reset unless it's something dirty. Then I'm going to bring him back and we'll take different measures. But you ever get called upon to test and you fail to go, it's not going to go well for you. Do you understand?
Yes, sir.
Take a seat for me, sir. Ms. Turner, this case is 220 days old. What are we doing? Where are we with it?
Your Honor, the last thing we have is that his license is not eligible, so he has to either rectify that or sign a no driving affidavit is what we have.
Yes, he's aware.
Okay.
We need to do that today as well.
Yes, sir. I'm just waiting on the application from him. He was working with the ODO paperwork. I will make sure it's done as soon as possible.
Okay, so no regular reset. I didn't realize it's as old as it is. We'll give him a week to get it done.
Okay,
If he doesn't have it done in a week, I'm gonna roll him day for day until he gets everything done.
will do.
Okay,
Judge Salazar?
Yeah. they haven't done it. I mean, he hasn't even done the application, Alex.
No, Your Honor.
Hasn't done shite, man. It's unacceptable.
This shows how much of a hurry I was.
Okay.
I wouldn't have put that there
Or just
split like that, so
test.
that shows I forgot to cut that clip out.
She's right here.
Oh, yeah, oh, sorry, yeah.
Have her s-
If she can sign up here, that's fine. Can I just tell her?
Yeah, absolutely, of course. Stand. No is important because you.
Yes, sir. Yes, sir. Guilty.
Ms. Bennett, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You guys have worked out the agreement where they're offering you 3 days in jail with credit for one. You need to understand that this charge is going to go on your record. It's going to be there for the rest of your life. It's going to be there, you know, it's even there after you die. This is important because you ever get pulled over again, officers, all they do is they look at your background. And if they see a lengthy background, it's just not going to go well for you. It doesn't matter if you're falling down, piss ass drunk. No, the mere smell of alcohol or dope, you will probably be looking at another DWI. What we're doing today, from now on, here in Harris County, you are facing, or in Texas, you're facing a minimum of 30 days in jail for any new cases that you pick up. Do you understand? No more proverbial slaps on the wrist. So if I were you, whatever you're going to do, don't get into a car because it's a humongous liability that you're in a risk that you're taking. You know, what Max is asking me to do is to take off around $3,500 worth of fines and fees. You know, the idea is that we all make mistakes, right? But you can't keep making mistakes where you endanger other people's lives. It's not fair. You know, when it's so easy to hit one damn button on your phone for $30 to $40, you have a car waiting to take you anywhere you want to go on this. Do you understand? I want you to understand one more thing. It's unacceptable the way that you have been treating us here in court. You were ordered to get an interlock. You have not had an interlock since August. It's not.
Judge, she did have it installed. There was a,
If it's in lockout.
I understand, and there's a.
It's as.
Issue with the money and all that, but yes, sir, we understand.
But you don't wait. If you
communicated with me, I didn't realize there was another option, Judge. And so I'm definitely taking the heat on that. So I came in to see if we could.
I'm not going to let you. You were old enough to know that if you're ordered to have an interlock and it's not functioning, you're going to upset a judge. Do you understand?
Judge,
just.
I'm gonna have to speak on that one, okay?
Yes.
Because I definitely communicated.
Let me know.
I said, I've been employed my whole life. When this stuff started happening, especially with the stuff with the other situation that happened going on, I let him know that I can no longer afford it. I didn't know there was another option.
And I neither, I told her we.
But
and
since
have
August, she's been in lockout, Max.
I have not drove, I Ubered everywhere I've been.
It's true.
I have.
And I helped her with that as well.
Yeah, yeah.
She had.
So now I'm self-responsibility for it, and I just don't want you to think that I just deliberately disobeyed an order. I didn't have a choice, and I communicated it with him. I'm taking full responsibility. So for you to tell me that, oh yeah, I mean I am old enough.
If you see, and the lawyer has been notified and still nothing is coming of it, you got to come to court. You know, when you have an interlock, it's supposed to be operational, and when it's not, that's a bond violation, and it's a continued one. You know,
I understand.
Look,
I'm taking full
I'm
responsibility.
preparing you for the future. You know,
Yes.
hopefully there is none, but you can't keep it.
Also, before all of this and the federal thing, she never been in trouble before. So this has been like.
No, I have an assault from 2010. I've got an ag assault in 2009. I've got a gun case in 24, you know, so it's not our first rodeo. It's not.
Okay.
And just.
She's like really upset about
The idea is we all make mistakes, like I told you, but don't make a mistake. I'm sorry. It's not a mistake. They're actions that you take, and you're old enough to know that actions have consequences, right? Especially when you're dealing with alcohol and a 3,000 to 5,000 pound missile that you're in. You could cause catastrophic injury, and that's what we're trying to prevent.
I understand.
All right. I am going to waive the fines and fees now, but you need to understand on a second offense, it's a minimum of $6,000 in surcharges and fines and fees if you pick up another DWI. So when people continue to make actions where they endanger other people's lives, it gets extremely expensive, not to mention costly with jail time. You understand? All right. The agreement you've worked out is 3 days in jail, credit for the 1 day that you've done. You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. So once you accept this agreement today, you can never change your mind. You can't say, well, I didn't know this was going to happen. I didn't know this. Once you plead guilty, it stays like this forever. Do you understand? You still want to do this? How do you plead to the offense of driving while intoxicated? I'm going to find you guilty. I will sentence you to it. I'm going to waive your costs, your fines and fees. There is a license suspension that is attached to this. I am going to suspend your license. I'm going to suspend it for 90 days. Do not drive until you get a license. Good luck, man. Thanks, folks. Please see the clerk.
Okay, we're just saying right here.
Delandre Burnett, she's here, and we may need to look at bond conditions.
Okay, Ms. Burnett, come up.
And I know she has a pending felony. The clerk's wet. I can't really pull the conditions up.
So we've got a ton of baggage here, and I don't understand how she has a discharging a firearm in an assault from October 29th. She picks up an aggravated assault in November, and then I guess the week later picks up a criminal mischief. So we have 4 open cases. Is that right?
Yes, Judge.
And we've never addressed any of the bonds.
She's been in custody for.
I don't know. Tell me.
She's been in.
When did you?
Okay. So she was in custody for, right, from October until January, Your Honor.
Did you just make bond on the felony, I guess? Is that what happened? Yeah.
Right.
All right. So a surety bond was posted on the ag assault on 1/9. So let's talk about the complaining witnesses in all these cases. Who are they in relation to the aggravated assault?
So in relation to the aggravated assault, we have not been able to make contact with complaining witness Johnson. But we have been able to make contact with the complaining witness Romero Perez, who was the employee at the business where the incident occurred.
Is this regarding the criminal mischief?
This is regarding the assault.
Okay. What happened in the assault, please?
So, she visited an office that day, and then the defendant began threatening the complaining witness's children, and then supposedly in the office is the apartment leasing office.
Okay.
And then she went up to the child and then threatened the child and said, the exact language, tell your mom that I'm still here, and pointed a weapon.
At the child?
Yes, Judge. A large kitchen knife.
That's a knife. Okay.
Yeah.
So the assault is out of the same transaction as the ag assault then?
Yes, she kicked the first complaining witness in the genitals, causing the employee from
Okay, now the criminal mischief is, where's that from?
The criminal mischief
For-
is from, a different complaining witness. He was at his home upon arrival. Officers made contact with him, and he advised that he was at his residence and wanting to watch their children, and or the defendant arrived at his residence wanting to watch their children. He did not initially agree. The defendant then became hostile and caused a disturbance. The defendant then drove her vehicle into the complaining witness's gate, damaging it, and subsequently reversed and sped away. Estimated cost to repair is $500.
And Your Honor, that they do have children together, and I believe the RIP call, he doesn't want to move forward with the case.
Something very interesting. I don't know if you read this, but, okay, ma'am, I'm going to find that there's probable cause on all your cases, and I'm ordering you as a condition of your bond not to be in possession of any weapons and not to have any contact with the complaining witnesses in these cases. Do you understand? Did the felony court put a monitor on her or anything like that? This is very interesting. Let me read this to you. As part of the conditions on the felony court, it says, defendant must obtain a library card and read to her children.
Oh.
/ must attend a parenting class. That's really interesting. I've never seen that.
228.
The 330. I don't know, but it says,
That's a visiting judge. That's a visiting judge.
interesting, right? Did you know about this condition? Okay.
Your Honor, one of the
I'm not going
CWs,
to impose that, but.
she
I
does
just
have
found-
children with, I believe, the complaining witness on the criminal mischief, which is about the gate. And so I don't, just to help them co-parent, I don't know if we could just have no.
But I don't know if he wants to have contact with her. You know, before I allow you to have contact with this gentleman, I would like to know if he even wants to have contact with you. What if he doesn't want to? He may be scared of
The
you. I don't know.
complaining witness did say that he asked her to drop charges
Yes.
on the case.
Okay, so I'm ordering you as a condition of your bond not to have any threatening or harassing contact with, is it Andre, right?
Andre, yes.
Okay, do you understand? What is threatening or harassing doesn't matter what you think, it's what he perceives. From what I go like this, that's could be threatening, harassing contact, so just be careful. You're lucky to be out with these 4 open cases. If I find that you're a danger to my public, you violate any of these conditions, I'm telling you now, I'm gonna make your bond extremely high. You know, you're probably not gonna have someone to pony up $15,000 worth of bond for you, so be very careful when you're out there. If you have a butting head relationship with this person, just be very careful. You understand? Now, we've given you a lawyer. It's your responsibility to stay in touch with Mr. Elick. If he tells me he can't get a hold of you, likewise, I'll issue a warrant for your arrest. All right? Okay, just be careful, man. Self-control. Okay, all right, Mr. Elick. I just need you to sign these conditions and then you're good to go. All right, thanks.
So is that pretrial bond condition?
Yeah, with Felicia. Yeah, no, no alcohol, no drugs as well, man. All right, okay, thanks, guys.
Judge, can we go over those one more time? Apologies. I thought these.
So no alcohol, no drugs, no weapons, no threatening or harassing contact with the gentleman named Andre, and then with the assault and that one, no contact whatsoever. And no going back to that leasing office as well. Okay.
All right.
Max.
There's one more order.
Right this way.
Okay.
Thank you, Judge.
Okay, come on, Trey.
Good morning, Judge.
Hi, good morning.
You're on a fugitive case, Mr. Kimball. Mr. Kimball wanted to talk to you about bond.
I'm happy to talk to you. Do you mind, please? I don't know who you are.
All right, everybody, this is going to be the last one for tonight. Now, listen to this guy's charges. Listen to how long this guy's been in the system and how well he thinks he can play the system. It's good to see Judge Fleischer push back on him and let him know how it's going to go. But this guy right here has played the system so much he thinks he can tell the judge how it's going to be.
How are you, man?
I had Julian down.
That's something?
We're gonna have a little bit.
Okay.
So let's get this.
Good morning, Mr. Kimball.
How you doing?
Pretty good. So I've never met you before. I don't know who you are. All I know is that your lawyer is asking me to, I'm assuming, set him a bond, right? You know, you're wanted from somewhere. I don't know for what. I don't know why. I don't know if I'm going to set you bond. I got to get to know you in the short time that I have you here to see, are you a danger to my community? If we give you a bond, are you going to go back? I have no idea. So let's get to know him. Amy?
Judge, so he's wanted from Guadalupe County, New Mexico, aggravated battery against a household member with a deadly weapon. As the court knows, he's also being held in the 351st for credit and debit card abuse.
No, I had no idea. Say it.
And I believe they also just filed a motion to revoke his probation on fraud use.
He's on probation too.
Yes, and they're motioning to revoke as well. He also has 2 bond forfeitures that I'm seeing, and then he has quite a bit of history with burglaries and.
My gosh. Whoa. So since 2007, possession of marijuana, possession of a controlled substance, evading arrest, possession of a controlled substance, felon in possession of a weapon, attempted evading arrest or detention, tampering or fabricating evidence, evading arrest and previous conviction, burglary of a building, possession of a controlled substance, burglary of motor vehicle, evading arrest, credit card abuse, burglary of a motor vehicle, evading credit card abuse, possession with intent to deliver. And 1, 2, 3, 4 more burglary of a motor vehicles, failure to ID, possession of a dangerous drug. You're on probation for a fraud. You pick up a new credit card abuse, and you want me to set you a bond?
Can I please tell you something? If you don't mind me speaking.
Don't talk about the case.
I'm not talking about no case.
Okay.
I was in here, been held on, the case for defendant violence in New Mexico, right? And they just got called ATW twice. They did not release me. I was not released. They sent me back to my cell. And since they didn't release me, they ended up putting a credit card abuse on me. Now, I don't know, where that falls in or whatever, they just put it on me.
So if I can give you a brief synopsis of the timeline, Judge?
Sure.
So January 15th, he waived extradition for his New Mexico case, which is why we have the fugitive. He also had a Dallas County hold at the same time, which means the Dallas.
He has another.
True, but Dallas County had 10 days to pick him up. So they did not pick him up in those 10 days. So let's say January.
I know that. I get it.
Let's just say, okay, so they didn't release the whole, they should have released the whole 25th. They didn't. What they did is instead, 3 days later.
Talking the Dallas County hold.
Dallas County hold. So what should have happened is that on the 25th, they released the Dallas County hold, which at that moment, there was no locals or anything pending, and they should have started the timeline for New Mexico to come pick him up. But instead, Dallas did not release the hold until I believe the 29th, because conveniently, on the 28th, the DA's office filed 2B charges on a credit card abuse from a case that they had had since November. So
December. I see here, December 22nd, 2024.
I'm sorry, from December, you're right. So it just seemed like the timeline expired. And I believe Mr. Kimball's just really upset because if it should have worked like it should have worked, then, why didn't they release the hold in time? Why didn't the DA's office file it? It just seems like they're sort of dragging it along. I understand that he does not have a bond on his felony cases, and they did file the MRP. He has an attorney there who is going to be requesting to set a bond there. What Mr. Kimball is asking is a bond here, even though, and I said, he's going to be making the bond there in felony. So let's say his bonds get set in felony and his bond gets set here. He wants to bond out and go to New Mexico, address that case, and then he said he'll be back and forth. He's already got the MRP and the felony credit abuse case here, but he wants to be able to fight them in the free world, and he is willing to go to New Mexico, turn himself in. I've been in contact with his mother, and I guess just because of that lapse in timeline, it's kind of like why we're here, because, in part, if you have anything else to add, I think he just feels kind of screwed by the system on this. Is there anything else, Mr. Kimball, that I missed?
Now, did she send the video to your phone? Oh, all right.
In 2023 alone, Mr. Kimball, you have 1, 2, 3, 4, 5, 6. In one of the misdemeanor cases, you have presumably a bond at 5,010, which tells me that you've taken off on that case as well. You're on probation. You had a hold out of Dallas for, what did he have a hold out of Dallas for?
Violation.
Out of Dallas?
You're hopscotching with the states with the criminality,
No,
man.
I got
can't.
them. Look, I had all the cases together and they gave me probation in Houston and Dallas. See, that's what you don't know. They dismissed a bunch of them cases has been dismissed. And I've been to trial twice. A bunch of them cases has been expunged on that record right there that you're saying. You know what I'm saying? But they gave me probation in Dallas and Houston. Dallas supposed to transfer my probation to Houston. They did not transfer my probation to Houston. That's how I get a violation in Dallas. I never violated by kissing any new case. Only time I caught a case is when for the New Mexico, say something happened in a family violence 2024. I never even been to New Mexico. The girl wrote a statement on me saying that I violated whatever. I understand. I know I don't supposed to tell you nothing, but I got videos. She's saying everything that she said is a lie. I don't even supposed to be having a case for I wouldn't even supposed to come to jail for that case. She has the videos in her phone. She can show you. She's showing her ID, everything, made a whole statement saying that everything that she said to me in New Mexico is a lie, bro. I'm just dry getting hold for this case.
We really.
I understand it.
It doesn't matter.
Yes, sir. I understand it.
It seems to me.
Yes, sir.
You get out, you pick up a new case. You were out, you just picked up a new credit card abuse 2 weeks ago. December 22nd, I mean, maybe 3 weeks ago, you just picked up another case. You're on probation in Houston. You're on probation in Dallas.
Yes, sir.
You got an open case in New Mexico.
Yes, sir.
I can't possibly give you a bond, Mr. Kimball. You know, I think that I need to protect my community. And if I give you a bond, I'm scared that something else is going to happen. I don't want you to pick up a 6th or 7th case, you know?
I ain't pick up a case. I came to jail for a case a year ago for New Mexico. I was already on probation.
Picked up.
No, they just put
Credit
a
card.
case on me while I was in custody. I didn't never get caught for anything. They just put a case on me while I've been in custody right now. This time, waiting on New Mexico and Dallas to come get me. They just put this case on me. They just put this on me.
I want to make sure that there are no more new cases get on you anymore. I'm not going to give you a bond because, Mr. Kimball, you scare me. You know, you do.
I never had an aggravated case. I never had an aggravated case in my life. You see my record. I never had an aggravated case.
I don't see, the only thing I see is
I'm saying everything you're just saying. I never had an aggravated case out of Harris County, Dallas, anywhere in Texas, ever. Ever.
I believe you, but it's just way too much baggage, dude. Way too much.
But I'm saying you can't just set a bond on the case. And when I go to court, you know what I'm saying? I talk to my other judge. She give me a bond on them cases or whatever, where I can go handle everything that I need to handle so I can get out and be with my kids. You know what I'm saying? Because if I don't, so say if they do set the bond when I go to court, because he's going to give me a court date in like a week or two. I'm going to go to court. They're going to set a bond for me. So they set a bond. Now I got to come back to your courtroom again for you to say, oh, well, I'm not going to give you a bond or whatever. They got 14 days to come get me. When actually I really supposed to already been gone to either Dallas or New Mexico because they called me ATW twice and they said they was not going to come get me. And we called to New Mexico. New Mexico said they didn't have any knowledge of me even being in jail on their warrant.
Is New Mexico, have they stated that they're going to come get him?
Our indication at this time is that they want him, Judge.
Okay, they're going to come get you. You know, the problem is that 14 days is told because you've not made bond on those cases upstairs. Once you do make bond at that point, that will get the 14 days for New Mexico to come get you. But Mr. Kimball, you've got a ton of priors. You're on probation in two different counties. You got to, okay, regardless, it's too much baggage. I'm not going to give you a bond. You scare me, dude. That's it. Really. You know, sometimes the bill comes due. Now is that time. It's not going to happen anymore. Okay, thanks.
All right, I'm gonna jump in there. So I looked up credit card abuse. Credit card abuse is when you use a stolen or fake credit card, which I always thought was credit card fraud. And it says using someone else's credit card without their permission, forcing the cardholder to make a purchase they can't afford, or receiving benefits from a stolen card. So I would have guessed that that's the same as credit card fraud, but I guess Texas has their own rules on that. But I think Big Tiff had the greatest comment there. You shouldn't have other judges. Anytime you go in and you're comparing judges against each other, you're doing too much and you need to get out of there. So, all right, we're going to end it tonight. We'll see you guys tomorrow. Thank you so much, and we'll see you next time.